So it's now 5 after 5, and I'm going to take this opportunity to start our second session for special needs planning. And this one's called Transition Planning and Beyond. And I'd like to introduce, and I'm going to read it again to make sure I do everything correctly. I'd like to introduce my guest speaker for today, Robert L. Potofsky from Potofsky PLLC. Robert provides estate planning for families, including special needs planning for families that have a member with disabilities or mental health challenges. Robert also counsels companies in the area of business law, nonprofit law, corporate contracts, and transactions. His experience also includes employment law, trademark, copyright, and litigation. Robert serves on the Business Advisory Council of ARC of Rockland and Camp Venture, and he is a member of the Board of Directors for the Rockland County Bar Association. But there's one important piece about Robert, and he wanted me to tell you that because he is a father of a child with special needs, he understands firsthand all that goes into special needs planning. So I'm going to take this opportunity to introduce Rob to you, and he is going to do a presentation. And at the end, if there are any questions, he'll be glad to answer.
Absolutely.
Go ahead, Rob.
Absolutely. It's my pleasure. I really appreciate the invitation. I always appreciate the opportunity to speak to special needs families. Beth, I know that you are, from all of our work that we've done on community boards together, where your heart is, and that you're a friend certainly of of the special needs community and the disability community, and just really excited to work with you on this project to make sure that we can work on getting this information out to families at their own speed and at their own time. So thank you so much, and I know that we have a number of people that are on the line here today. And then also, obviously, that this will be made available to other resources. So thank you again for those, for that opportunity. Just wanted to go through. We're going to be covering a wide range of topics, sometimes at the 30,000 foot level, I will admit, and then sort of dipping down, into some practical advice. Hopefully, some tips that you can take away. Some of the goals, of course, for this. You'll see, obviously, the agenda that we have here is hopefully to take away one or two items that maybe you hadn't thought about, and to obviously work with our teams of people that are working with our families to make sure that we're empowered to ask the questions that we know our kids. We know what's best for them, but sometimes with a little data and with support and making sure that we have the right people around us, we can move the bar even further forward for them, which is even more critical for our kids as they move through transition. And when we talk about transition, we're talking about those kids that are, primarily looking at the later middle school and into high school, into those age groups, and then into young adulthood. The issues as you continue to advance become more challenging. There are similarities. Yesterday, I did have the opportunity to speak on some issues that affect those that are elementary or younger kids, school age children. But there are other, in addition to the school challenges, as with life, things get a little more challenging as we continue to move towards adulthood, and for our community, it's important to have that conversation. So we will be talking about transition planning, talking about the school-based approach, the community, a little bit on the community resources that are available, some state resources that are available, especially on the vocational side of the house. One of the important things here you'll see, taking care of the caregiver, estate planning is really, really critical. It becomes it's something that we all need to do. It's something that we generally we put off, and especially special needs moms and dads. We put that off because we're so focused on our kids' well-being that we forget that our inheritance, the wealth and what we've been able to accumulate during life can have a very important positive effect on our children, but we do have to make sure that we're taking into account the best way to move assets to the next generation. some tips on how to create that plan. And again, since we are talking about transition, and again, depending on the level of our special needs children, decision making for our children become important, because when kids become 18, they are emancipated. They have the legal right to make decisions for themselves, and financial decisions, healthcare decisions, day-to-day decisions. That's the law. That's how this process works. So if they're, engaging in an honest conversation about their capacity, their ability to make those decisions, what sorts of supports need to be in place, a guardianship conversation may be important. It may be something that we would want to take a look at. Again, we're going to be going over the two methods of guardianship as well, just discussing what those look like and kind of what would be involved with that. So just again to let you know, this is our family. We are very blessed. It's a busy time, as Beth mentioned. I am a special needs dad. I'm newer to the special needs community. I had started my practice as a business not-for-profit attorney, and recognized the needs of so many families, so many business owners, and then so many families that have been touched by somebody with special needs. And I've been very blessed to be involved with so many of our local agencies here in the Lower Hudson Valley, working with them in support of their consumers, their agency, and their goals. It's a very loving community. And so I just encourage you to always know that you're not alone, and that there are resources. And if you have questions or feel that you need to bounce some ideas off of, certainly to reach out to Beth, to reach out to myself. We can make sure that we're going to be able to get you to those resources, because it is a community. It takes a village to raise a child, and especially one that have unique needs. So just jumping in first to our transition planning, which again, primarily talking about a school-based approach, especially with our high schoolers. It's critical to make sure that our children's voices are heard. Now, there are requirements in when you're dealing with an individual education plan or an IEP or a 504, that children actually participate in the meeting. But it's one thing to participate in the meeting and to be sitting in the meeting, but there needs to be pre-planning. There should be conversations that are had between parents and administrators, and also those on the special needs team, the ones that are doing evaluating, their educators, and providing services of how to make the meeting the most beneficial for the student. Because in this meeting, we're, as you see here, we're going to be, the conversations are discussing, what the child wants to do, especially, as you move from the earlier ages and you move into high school. There are, some of the conversations can be quite challenging, because you're going to have experts that are sitting around your IEP table, and they're going to be talking about strengths and weaknesses. So the question is, how will that be heard ultimately by your special needs child who's sitting in that meeting? So how much detail should you be getting into at that conversation? How is that information couched? There's tremendous, as we know, our children are certainly evaluated and tested, and there's metrics that go in, and obviously, there the variety of areas that are, there's a tremendous amount of data, depending on the child that perhaps has issues with self-esteem or other mental health issues. Though it's important to recognize who your audience is, and that it's important. But on the flip side, we need to make sure, as you see here, that we are presuming that your child is is able to, with reasonable supports, achieve success. Success needs to be able to be measured, and again, to make sure that your child that's sitting in that room, which can be a little overwhelming. Normally in person, but obviously at this point is happening through Zoom. So you have a number of boxes. Can be quite overwhelming, especially the first time that that they're attending a meeting. Again, as a school-age child, they're not attending these meetings. So this may, so if it's that first transition meeting and they're actually starting to attend these meetings, a game plan, an approach is definitely works out better. But and again, the conversation will shift. Besides also just focusing on school base, as you see here, career planning becomes a focus, a vocational, vocational portion of this. And what does post-secondary life look like, and how can the school support that? And that's our job. That is our job as parents, is to make sure that we're able to make sure that the school stays focused on those matters. So as you see here, obviously the IEP, it's been to say it's been tough is quite the understatement right now for many of our families, and I hear it every day. Fidelity to our IEP plans. We work so hard to discuss our plans, to work with our teams, to do the evaluations, and then in March, the whole world shut down. I mean, in terms of COVID. And we had our children that were used to be getting in-person educational related services, special education classrooms, et cetera, that has now been shifted to an online setting. Related services, even including, occupational therapy, being delivered at home in front of a screen. That creates real challenges. Number one, it is important for all of us to remember that even despite all of these challenges, the IDEA, which is the federal law that oversees special education, is still good law, and it hasn't been waived. Your rights are not, have not been waived in this, even in this pandemic. So it's important to make sure that you're taking notes and that you're recognizing exactly where your child is, where they're struggling, and if they're regressing. And if you're seeing that, understandably, in a lot of cases, you're seeing that regression, you're seeing that even that services, either they can't or they aren't able to be, or they're not working, et cetera, in terms of the delivery, you need to be empowered. And I hope that this is one of your takeaways, to raise your hand and say, this is not working. We need a progress meeting. We need to call a progress meeting now. As you see here, a parent has the ability to call a progress meeting at any time and to assemble the entire team to review those IEP goals and to make sure that has there been a change since the annual meeting? Well, many folks had designed their IEP goals for a more pre-COVID environment, let's say. In other words, anticipating that they're going to be in school and that they're going to be receiving those services. And maybe the IEP didn't adjust. Well, that needs to be done. And it's important to make sure that we're saying that, we're raising our hand and speaking up. And as you see here, if the IEP is not being followed, that as part of that process, a parent can request for the school district to provide compensatory services and educational opportunity for your child to make up and to close that gap. There is no blame. It's all about partnership, ultimately, between our school districts, who of course are going to take us through the long haul, and parents. But still, it's important to be firm and to make sure that we're advocating, in that way, to make sure that we're speaking up and making sure that our child's voice is heard. Hopefully we will be hearing it. It is part of the process, and that our school districts respect it. So in addition, in terms of transition planning, as you see, no later than when a child turns 16, the transition planning portion of the IEP sort of springs out. We spoke about, this wasn't part of this, the school age, but then once you're starting, because once you're in high school, there starts to be that push towards the post-secondary. And so it's really critical to have an opportunity to discuss those plans openly and honestly, and with the child, to identify vocational efforts, their goals, and what's expected and what they need to be able to do this. We'll talk a little bit about Access VR services as another conduit to be able to provide additional supports. It's almost like a hidden gem, which can provide a tremendous wealth of supports that can start within high school and can actually run through young adulthood and beyond in terms of vocational services. And there may be resources that are actually in your school that can be literally brought in to your IEP meeting, which are really critical. We talk about goals. I spoke about them on the last slide. I'm going to mention it again here. It's critical for them to be SMART goals, because if we don't have goals that are measurable, that are achievable, and time-bound, we're not going to know whether whether they're reasonable and effective. We also have to make sure that the school understands that there is a level of commitment in terms of the monitoring and providing data to our team, ultimately to the parents, et cetera, to make sure that they see that. It's not just, oh yeah, absolutely, progress is being made towards these goals. How do you know this? Who's who's actually looking in the lunchroom? Are you is a teaching assistant tasked with this role? A special education teacher? What are the metrics? Is there a chart that's being identified? So that way, that data, the empirical data, or even anecdotal, in terms of what folks are seeing, whether it's a diary or a log, et cetera, is being brought to the table. So they can so when you're evaluating and looking to see whether SMART goals were achieved, you have something behind it and not just a general feeling. So as you see, obviously, again, amplifying the child, your child's voice in the transition process is really important. It's everything. You're not just talking about this is a plan which they need to buy into, obviously, because we know as a father of a teenage daughter, things can get when you don't have buy-in in that way. Progress can be stopped, certainly. So it's critical to make sure that they're fully brought in, and that this is a safe space to be able to have those conversations, and that this team is assembled to help them. Wanted to talk a little bit here about Access VR, and this is something that you can actually bring up, as you see, as early as a high school junior year. You actually don't need to have an IEP, an individual education plan, or a 504 plan in place to apply for Access VR, as you see, the New York State Vocational Training Services. The criteria are listed right here. It is a separate process. I will say that having an IEP in place and being classified through the evaluation process and receiving school level services may it creates some momentum, and obviously can help to check off some of the boxes here. But who else can do this? The guidance counselor is also going to be very important as well, and can be incorporated. In many school districts, there's actually a representative that's connected with Access VR, that if you raise your hand, we're back to advocacy again, you have to raise your hand, they can actually be brought in. And as you see, if you're approved separately by Access VR, which is under the New York State Department of Education, you're able to have access to a wealth of actually funding and other career opportunities, certain types of career counseling and assessments, depending on, and there are some means testing for the family, but they'll actually, depending on what the vocational needs are through the Access VR process, they may pay for college. You actually would be able to get up to a SUNY or CUNY level of tuition, and potentially some room and board and books and other supports, so long as it falls under the Access VR system, and obviously other academic supports. So as we're talking about those high schoolers, I would say reflexively if you have a child that's reaching these ages and is, and is need of special education supports, there's no harm, there's no application fee in raising your hand and say, I want a referral to Access VR. I'd like to see the application and be able to see whether there's an opportunity to work together. It's a real gem. It's a real gem, and also can have those long-term impacts as we, as we proceed forward. But as we know, sometimes things don't go well, and we have challenges. And school districts, whether you're pre-COVID or in a COVID time, sometimes they don't make the mark. Again, we've spoken about goals, we've spoken about metrics, and you're also, as parents, you're going to know when your district is deficient and is not able to provide that support. So it's important to know, again, that we need to raise our hand. Least expensive, of course, is an informal proceeding, up to a mediation process. But it's to speak to the building principal, go beyond the teacher and the guidance counselor. Go back to the team, go back to the principal, go back to the school district itself, and say, look, this is not working. I don't want to go through the process because it's time and money and effort to be able to challenge the development and how this is being carried out. But let's continue to work in partnership to do this. But I wanted to just briefly raise, as we kind of continue through special education, there are formal procedures and processes. Primarily is it's called due process, which ultimately would involve a hearing in front of an administrative law judge, where it's the district and the parent, with ultimately the ALJ making determinations based on evidence consistent with those rules, to determine whether the school district was deficient and can order certain things. Again, we're all about partnership, and I know obviously so many of our families, this approach of being able to reach out and use the less intrusive method typically works. It's also critical to know that working sometimes with a special education advocate, which I do as well, may help. These are special education teachers that have tremendous experience, and also can speak in that way. As I said on yesterday's Zoom, sometimes bringing a lawyer into the process changes the dynamic a bit. It can. So it's critical to weigh the pros and cons on how you're going to proceed, because ultimately, remember, anybody that you bring in doesn't live in your community. They don't live in your school district. They aren't in your school. So these are very personal decisions. And again, unlike you have a contractual dispute, maybe you can just walk away. It's a little harder to walk away from a school district, especially neurotypical special needs, etc. There's that long-term process. It's a give and a take, and we know. Obviously we have some green issues, and obviously some that are, break the glass red issues that need to be addressed. So from here, wanted to make a bit of a pivot from our special education and discuss planning. As I said at the agenda at the outset, it does start with us as caregivers. And I've seen this so often. These are difficult topics, and obviously, those of us with special needs kids, it becomes even more important to make sure that we're doing that type of planning right now, to make sure that our loved ones understand what our wishes are, and to make sure that our loved ones' special needs, our neurotypical, are taken care of, and that our assets move in the appropriate way to make sure that we're protecting benefits, which we'll be discussing a little bit later. First is incapacity. Incapacity. This has been highlighted so much, I think, over the last couple of months. I mean, the New York Times did a story only a couple of months ago on which broke my heart in terms of healthcare decision making in light of COVID, when we're not able to have access to our loved ones. and we are, you know, we are not, and when our loved ones were not able to express those needs, and now we're even a step removed from that. So it's critical for all of us, for all of us, to go through the process of selecting, informing a healthcare proxy, somebody that's going to be responsible for making those healthcare decisions when we don't have our voice, and then also to educate that proxy in terms of how we want our healthcare to be concerned, talking about organ donation, talking about nutrition and CPR and those sorts of issues, to make sure it's in writing and that we have conversations with people. This is as I do the plannings with my families, I make sure that that we are making that our families, the people that are my clients that are sitting in front of me, are turning and speaking to their loved ones. At least I encourage them to. These are sometimes difficult conversations, where the documents are located, and also to make sure that that those wishes are carried out, because this is intensely personal. What happens when you die? Obviously, everybody having a will. We're going to be talking a little bit about about using trusts to make sure that monies again flow into directions that are the most safe, maybe potentially for our neurotypical, but especially for our special needs children, because that could have an impact. Many of the benefits that we're just that benefit our loved ones are means tested. So it's important to make sure that those monies flow in a particular way, and it's overlooked, generally, because estate planning generally gets overlooked. It's certainly even overlooked when our families are trying to get through the day to day. So it's an important topic. We need to answer these questions, and put down in writing, who's going to be responsible for making these important decisions. Back to our children, as we talk about our steps for creating a plan, one is to envision their future. And I think it's really, really critical to have an open and an honest dialogue with their team, with them, in terms of what they're capable, what they're able to do, what's reachable, and then also with their team, depending on what medical personnel they're working with, whether they're working with mental health support, other vocational support, and to be able to answer these questions. The more honestly that we can answer questions for our older children and our young adults, the better we're going to be able to plan. And we all do it in terms of potentially making rosy predictions. But we don't realize sometimes, I think, as parents, that we may be compensating. We may be providing that level of support, sort of like just reflexively, just because we're doing that. But sadly, we have to imagine a life without us there, without us providing that support. So then, if not there, how do we answer questions like that? Can they live independently? What level of support is going to be required to be able to do that? And then obviously trying to look at the types of challenges that they may have, and where can they go to be able to get support, and who needs to be around them to provide that, to step in and provide that support. Again, when we're not there, that's part of the planning process. As we do that, we then can create a memorandum. Now, a memorandum of intent like this it's not a legal document. We include that next to, it's kept with the will, but and the other estate planning documents, but it can be life-changing when you're not there and not able to set this out. Because again, whoever's identified as a guardian or responsible, maybe a sibling responsible for taking care and supporting your special needs child, they may not know all of these things that we do as parents. They may not know their favorite foods. They may not know what their triggers are, who they're, who sets them off, etc. This can be as detailed as possible. And again, the beauty of this document is that you don't need an attorney to draft it. This is something that you can have. I mean, we provide my clients with forms to be able to assist them, but this can be changed as life changes, as their interests change, and as people come in and out of life, as what happens generally. So it's really, really critical to spend some time and to go through that process and make sure that that's spelled out. It can, again, as I said, it can make all the difference. And then looking at your children, these are now children that are going to be 18, and looking at their income. Again, we're focused specifically more in terms of these slides, in terms of those that are going to be applying for means-tested programs, such as SSI, SSDI, other kinds of Social Security, other kinds of housing benefits. A lot of these benefits are means-tested benefits. And so it's going to be important to sort of, as we would generally, to get an honest assessment and to work with our financial planner and to work with our accountant to make sure that we're getting a real sense of what this looks like. Again, this is even more critical for special needs families, especially with those that are, with their loved ones that are more affected, to make sure that we can understand as soon as possible what that shortfall, as you see here, is. Because I'm sure Beth can answer better than I can, that there are opportunities to be able to fill in those gaps and to create that, opportunity, through different means. Beth, I don't know whether you had something to add on that.
Well, one of the things we have to understand now is that we don't want other people to leave our children money. So we have to make sure that all of our family members know, because there are times when all of a sudden a grandparent or an aunt or an uncle thinks, oh, I'm doing such a wonderful thing because I'm going to leave money towards a special needs child, and then they can really ruin the entire plan. So everybody needs to be informed about the special needs trusts and the needs and objectives. But there's one thing right now that we need to understand, and that is, we used to tell all of our clients not to leave IRA or retirement plan money to a trust for a special needs child because it was so complicated. Now with the new Secure Act,
yes,
a special needs trust can actually stretch an IRA where no one else can.
Great.
So a lot of times we've set all this up and we don't have our IRAs, beneficiaries, our special needs trust. And the answer is, oh, maybe we should start changing some of our beneficiary designations, because right now, a special needs trust is a good place, a good beneficiary for an IRA.
That is such a great point. It is, it's a different world, isn't it? It is a different world.
It changes all the time.
It changes all the time, and especially as it relates to IRAs right now. It has completely topsy-turvy. But in terms of this, you're absolutely right. This is someplace where you can get that stretch as long as we do the proper planning. And as you know,
and the proper trust,
which we'll see on the next slide, because obviously the trust is so valuable. Because as you see, when we're talking about Medicaid and SSI, these are means-tested programs. So let's look at your child who's now 18 years old, and they, in order to qualify for these benefits and potentially OPWDD, Office of People with Developmental Disability Benefits, they are connected to your eligibility in terms of Medicaid and SSI. So let's say, to Beth's example, we have a grandparent who loves their child, loves their grandchild, and they look to make that transfer, and they transfer it directly to them, in all without in complete love and certainly no ill will at all. But what that can do is there are income and resource limits in terms of some of these means tested programs, and the problem is that yes, things can be cleaned up. I'm not going to say they can't be cleaned up, but what it does is, on top of you know, on top, to be honest, in the scenario, on top of the grief of the loss of a loved one, you would then have your special needs child inherit money, which then would be considered not income. That would not be income. It's not monthly income, but it'd become a resource. And there would have to be scrambling done at that point, which, you know, in terms of having to move the money, and then it's first party money, and then maybe you'll need to go into court to be able to create that. And again, that takes time. You may have to rush in and hire an attorney at that point to be able to handle that process. It becomes a bit challenging. Again, we're able to kind of get there, but it's challenging, it's stressful. We're talking about planning. The idea is to try to stay away from that. That money, it's coming from, right, back to the example, it's coming from, it's not their money, right? This is grandparents' money. So the better plan is to use a third party special needs trust, or a supplemental, as you see here, a supplemental needs trust, special needs trust. The terms have been used interchangeably. What this does is it creates that separate box. And the beauty of it is that when it's created properly, it's blind to those benefit programs. So they're able to hold those monies. As you see here, they supplement, don't supplant government benefits for the, you know, for those special needs. And quite frankly, you don't have to wait, as you see, you don't have to wait until somebody passes to have one created. You can actually establish, parents can establish what's called a living trust, an inter vivos trust. Establish the trust, go through the process. It has its own, its own tax ID number. And then again, it comes back to communication, talking to our loved ones and say, look, there are these needs. There, your grandchild is applying for these benefits. So if you're going to want to give money, as a legacy to them, here's the information. There's a trust. I'm not saying to put it in now. That could be discussed too. If maybe they want to move the monies during their lifetime and see it through. But at a minimum, they'll be able to update their documents to reflect the SNT, the third party SNT. And they can do this again in terms of, probate assets, those that pass under their will, or those assets that are held at financial accounts as well, and maybe it's just changing those account beneficiary designations and making folks aware, and then things flow, and then you're planned, and then and there isn't that worry. So I really appreciate your raising that, Beth. Finally, again, we're sort of continuing to kind of move our way through is guardianship. It's decision making. Now that first question is again a joint project. As parents, we can see certain, we recognize, we see certain things, how our children relate to money management, checking accounts, and vocation, taking care of themselves, day-to-day care. But it's important, as we'll see on the subsequent slides, to make sure that, we are bringing in our team and we're leaning on our team of our medical team, our psychoeducational team, et cetera, to make sure that we're understanding, like, is this going to be necessary? And we're going to go through it a little bit in terms of the guardianship process. But it's a process, and it's a big, it's certainly a big step for many. For some children, it becomes self-evident, but there are opportunities where perhaps a less restrictive method would be able to protect the person and also protect their rights, and ability to function. As you see, if you hear, we spoke about a durable power of attorney for us. That's obviously something that that can be extended, and also other mechanisms as well, including a psychiatric advance directive as well for those with mental health issues, which again would be less than a guardianship. But obviously, it's important, to recognize that there may be the need to manage the personal day-to-day and the property of children. Because again, that first bullet is just critical. It's critical to remember, and people, it surprises people because we're living in we live in a school environment, right, for such a long time, and the services flow in that direction. But at 18, if it changes, it cuts off. And so if that default rule is a problem, we need to make sure that we mind the gap, we're aware of it before 18, and that we're doing what's necessary to put in place guardianship if it's necessary. So there are two types. We're going to go into a little bit of detail on this as well. There's two flavors. The first one is the 17A guardianship. This is the older guardianship method, primarily, though also for traumatic head injury, but primarily for those with developmental disability. This type of guardianship, I like to say, is asking the court to continue the parent-child relationship as if they're a minor, as if your child was a minor, after 18 and beyond. It's a light switch. The 17A is a light, think of it as a light switch. Once this turns on, basically the ward, who is the individual, that's the special needs child, then those rights are basically transferred to the guardian reflexively, like under this mechanism. This was created in the 1960s. This is the mechanism that's still in place. They're still discussing possible amendments and changes that are still going through, but it's primarily still the same. As you see, the diagnosis has to be certified to a court from two physicians, ideally one treating physician and a psychologist. Petition is made by several people. The parent can make it, the individual can make it, or a not-for-profit, with a standard of what's in the best interest of the child. But as you see, in terms of the applicant, because it is so reflexive, simply being able to identify the diagnosis of the developmental disability, the judge picks up a pen. I mean, it's very, it's a light switch. As you see, it's an indefinite duration. There, again, getting back a little bit into civil rights law, there have been, and this is a continuing conversation amongst colleagues at the bar. It's indefinite. It's very, very difficult to end a 17A. Because again, it's just based on, it's based on the diagnosis. So as that continues, which it does, because obviously we're talking about a developmental disability, that becomes very tricky. And it's creating a lot of heat and light, and continuing, on this. As you see, this 17A, when we have the flip of the switch, wholly removes from the ward, who's the person that's under guardianship, decision making related to their medical care, where they live, potentially who they're talking to, travel, employment, as you see here. It's all or nothing. And that's why, for a lot of children, there isn't, a lot of this is done on the papers. In other words, you don't actually need, even though you're in court, you don't actually need to go in, and the judge doesn't have to intervene, because again, it's a diagnosis based. If you check, this is a check the box circumstance, 17A is there. Again, it's a little bit of an editorial, obviously, but it's important to recognize, which is why I talk about least restrictive as well. Just because a diagnosis is there, that may not mean that you need to go to a 17A. It is less expensive than the one we're just going to be talking about. I'm not saying that. And I'm not saying that there's opportunities and needs for these types of guardianships, but I feel that it's important for our families to go in with eyes open. A little bit newer is a more functional 81, or Article 81 guardianship of the mental health law. As you see here, it's not diagnosis driven, but provides it actually will look at a more functional assessment and more flexible means of looking at how to set guardianship up. But in doing so, it's a lot, it is a lot more expensive to administer, because the court has to appoint a team of people, including an attorney for the AIP, the alleged incapacitated person, which has to be paid. Somebody's got to pay that attorney as well, separate and apart, perhaps, from the parent's attorney, separate and apart from the court referee, separate and apart from. There has to be a team that's going in. But what this type of guardianship does do is it allows that separation. So perhaps they're able to manage money, but they have trouble in managing, their healthcare issues. And you can maybe able to separate that out. Whereas, as we remember with the 17A, it's a switch. So as you see, it's a family member or another interested party that can bring that 81. The court appoints a court evaluator and an attorney to make sure, again, that the voice of your child is heard. And then the court evaluator is the eyes and the ears. And they have to do a substantial evaluation of the circumstance to determine specifically what is needed, which, as you see here, has to be proven by a higher standard, by a clear and convincing evidence that they have they have limitations, which require that guardianship. As you see, it's not a switch. The authority of the guardian, which can be altered as well, is governed by court order. Now, of course, it's governed by court order, which means you do have to go back in. You may have to go back into court and seek those changes, but it is not all or nothing. Balance, right? So that's the balance there. So the duration is not indefinite. It's based on the need. It's based on the functional need. There is training as well for folks that are evaluating and examining, and obviously those guardians as well. There's reporting requirements for the person in the property to make sure that people are checking in. Again, this type of guardianship, for those that are higher functioning and have more of an ability, but to make these decisions, this becomes a little bit more beneficial. But of course, with all of that judicially ordered support comes more dollars, right? Comes fees, more reports, more personnel, and those monies obviously come out of the ward's assets as well. So that becomes the balance. But depending on the circumstance, that's another option. So again, a few takeaways here. Hopefully this is provided some background in terms of our special education process, in terms of our vocational access VR, to make sure that we're having those conversations and empowering our children to make sure that they are engaged in that process as they look forward to post-secondary. We talk about a memorandum of intent and talk about that financial need, work on life insurance, work on our investments, and making sure that we are creating for our children that are going to need public benefits, a third-party SMT, which can be contained within the will itself, when the will actually becomes a trust document, or it can be a separate standing living trust which can potentially capture some of our assets that we want to move to our loved one, or for others that want to bequest to them. Obviously, that could be funded as well by life insurance. And then encouraging and having those conversations with our loved ones to make sure that they name this SNT as beneficiary of wills and their trusts and financial accounts, their retirement plan, their pension, whatever assets are looking to make that move to the through the generation. And then again, we've obviously spoken about decision making for your 18-year-old as we go through transition. That's a big year, and it's critical to have our eyes open to make sure that there's a wide range of decision making that can be used. up to and including court-ordered guardianship, which is available, and to make sure that we're working with our team to, working with your team to make sure you identify what is the best plan for your child. And finally, of course, because it's, a critical thing that all of us need to do. We need to do our will. We need to do our power of attorney. Do our advance directives. Speak to our loved ones. It's even more important for us with those with special needs to make sure that we're doing that, to make sure that everything is wrapped up, put into the best circumstance to create that peace of mind and the best opportunity to make sure that our children can live their best life. So I really appreciate the opportunity to speak with all of you today. It's really a passion of mine to take care of our families. So Beth, again, thank you.
Switch to your next slide, the one that has your name on it. So if you
Thank you.
like this presentation and there's things you don't remember, please email Rob and he can send you a copy of the presentation. Also, if there's any questions you have, because a lot of people are going to be listening to this later, then you can email Rob and he will answer any questions that you might have. Also, there's personal questions that you don't want to ask to everyone. You want it to be private. Again, email. And if, you can always email me at bflecker@easternplanning.com, or you can give me a call at 845-627-8300, because it's very important to have as much education as you can, especially if you're dealing with a special needs child or a special needs adult. And today, some of us are in that position where we have to handle our parents, and they have some special needs now with dementia and Alzheimer's. So there's a lot of issues that are coming up. And because of where we are now, and we're in that age of COVID and not going out, I will bring on more people to talk to us about different topics. But Rob, I truly appreciate you coming on. And
My pleasure.
I really thank you for giving us so much knowledge, 2 full evenings of knowledge. And it is, I truly appreciate it.
It's my
If anybody here has a question, I'm actually going to turn the record off. But if anybody here has a question, questions.